backwards or forwards. Anyway, I'm going to come on now and just on the final slide, look at Brexit in the last couple of minutes. There are obviously a lot of implications with Brexit, but we're just focusing here on the implications for international data transfers. The transition period for Brexit, as everyone knows, comes to an end on 31st of December. So what's going to happen then? At the end of this transition period, the EU GDPR will come into UK domestic law as UK GDPR, and it's basically the same. There are a few little tweaks here and there to make sure that it operates in the UK, but to all intents and purposes, EU law and UK law will continue to be aligned on data protection after the transition period. But what about international transfers to and from the UK? So as regards transfers from the UK, there's no immediate changes. Transfers to the EEA are okay, there's no issues. And transfers to other countries, such as the US or elsewhere, then existing adequacy decisions will continue to be respected, and the EU-approved standard contractual clauses can continue to be used. So that's the good news. There's continuity in terms of transfers from the UK. A bit more difficult in relation to transfers from the EEA to the UK. Once the transition period comes to an end, then the UK will effectively become a third country outside of the EEA. And the European Commission can deem the UK to be an adequate territory, known as an adequacy decision. And that's what we're hoping for as part of a Brexit deal. We're currently going through an adequacy assessment to decide whether we can have it. These things normally take several years, and it's a bit of a stretch to imagine that we will get an adequacy decision by the end of the year. Although there might be some sort of transitional arrangement if there's a Brexit deal. If there's no deal, then there will be no adequacy, and we will be a third UK will be a third country. So in that scenario, as we discussed, the most straightforward solution in terms of transfers coming from the EEA to the UK will be to put in place standard contractual clauses. You could do that now in the run-up to the end of the year, perhaps with a condition precedent that they will only kick in if there's a no-deal Brexit, or you could do it early in the new year if you want to wait and see how things turn out. Of course, the position is a little bit more complicated because we've now got the new standard contractual clauses, and it looks unlikely that those clauses will be adopted before the end of the year. So there's still an option to use the old clauses up to the end of the year or early 2021, with a view to putting in place the new clauses once they're finalised and a bit later on. So a little bit of a messy situation around there. So in conclusion, we've covered a lot of ground very quickly, but it is a really big ask for everybody to put in place transfer impact assessments, implement supplemental measures, put in place new standard contractual clauses, especially for businesses facing already a lot of regulatory and other challenges at the moment, who may not have access to large amounts of resources. But from a legal compliance point of view, it is necessary to start doing something in this direction, particularly in terms of the impact assessments and looking at supplemental measures, and importantly, to document what you're doing, as Ben said. From a practical point of view, there'll need to be some commercial risk-based prioritization of international transfers. Where your transfers are using substantial service providers overseas, then one can hope or expect that they will take the lead on some of this in terms of they have to provide a compliant solution for their customers, which may include things like off-the-shelf assessments. But we should have to wait and see what happens with that. For UK firms, after Brexit, we can look to see whether the ICO will offer any more pragmatic guidance, a bit more pragmatic typically than the EDPB. But there again, they may not be able to do that because if they do dilute the data protection laws to any respect, then that could jeopardize the UK's adequacy decision. So we'll have to see how they manage to finesse that. So as we await these finalization of these new standard contractual clauses, it's necessary to get started on the initial transfer impact assessment, keep these developments under review, and prepare for a busy 2021. That's the end of our formal remarks.